Hi, everyone. Thank you for joining us today. I'm Marche, the Webinar Director at Advice Chaser. Before we introduce our guests and get started, I do need to do a bit of legal housekeeping. Advice Chaser, the host of this webinar, is not a registered investment advisor. We cannot and do not give financial advice. Today's presentation is for educational purposes only and cannot be considered advice for any person's individual situation. Advice Chaser regularly hosts informative webinars such as this one, featuring a variety of knowledgeable professionals, many of whom are licensed advisors. Any opinions, ideas, jokes, or principles expressed by presenters are their own, and however true, funny, or interesting are not endorsed by Advice Chaser. Please do not act on the information you hear today without consulting a qualified financial professional. Well, we're thrilled to bring you this educational presentation today. Attendees are muted, but we do encourage you to ask questions using the chat box. And if you ask a question in the chat box and we don't have a chance to get to it, go ahead and leave your phone number as well. We're happy to reach out to you after today's event to make sure that that question has been addressed. Once again, we want this experience to be as educational as possible. Please don't hesitate to reach out to ask for clarification or expansion of the material, and we'll do our very best. Well, we'd love to introduce you to today's speakers. Our moderator today is Joe Dallow, and he is an accredited investment fiduciary with Dallow Financial. He enjoys serving his clients and helping them plan for the future. He and our guest speaker, Scott, both earned their law degrees from Thomas M. Cooley Law School at Western Michigan University. And our Scott M. Robbins, who's presenting today, is a partner at Baron Rosenberg, Majoris and Majoris. He concentrates his practice on estate planning, elder law, Medicaid planning, veterans benefits, guardianships and conservatorships, and special needs planning. Selected as a rising star by Super Lawyers magazine since 2018, 2019, and 2020. He has also been recognized as one of the best lawyers in America, ones to watch. And I'm really excited to have this team here today to answer your questions, present to you a little bit about probate. And Joe, I didn't have a chance to let you say hello, so why don't you go ahead and say hello really quickly?
Yeah. Hi, everybody. My name is Joe Dallow, and thank you, Marche, for having us. Like Marche said, Scott and I went to law school together, and we've actually done a webinar previously that worked out well, and we wanted to share some more information on probate now. And Scott, you can go ahead and introduce yourself as well.
Hi, how's it going? My name is Scott Robbins, and I'm looking forward to sharing a lot of what I know about probate, try and clarify some of the misconceptions that a lot of people have, and hopefully it can answer a lot of questions that you might also have as well.
All right, we're ready for you to talk a little bit about the basics of probate, Scott.
Okay.
So Scott, probate gets involved when a person dies, right?
Well, there's actually two major areas where probate would get involved. The one that most people know about is death, specifically addressing where the assets of a deceased person goes. The other, less known probate area is incapacity, and that is needed when a person lacks the ability to make and communicate informed decisions, or they lack the ability to manage their property and business affairs.
Why exactly does probate need to get involved?
Well, if a person dies with assets in their name and there is no joint owner or named beneficiary, you can think of it like an orphaned asset. In order to transfer that asset to a living individual, the probate court needs to get involved. The court needs to appoint a manager called a personal representative in Michigan. Some other states might call it an executor. And that person is going to be legally authorized to take control of the assets and distribute them according to the individual's plan. If a person is alive but unable to make informed decisions, or unable to manage their property and business affairs effectively, the probate court needs to get involved to appoint a manager for that individual themselves. A health manager in Michigan is called a guardian, who determines care, custody, placement, and treatment decisions. And a financial manager is called a conservator, who controls the financial aspects of an incapacitated individual's affairs, such as paying bills and filing tax returns. The probate court is also there in some instances to answer questions or to decide how to handle ambiguities. There are countless situations where a person's documents are often prepared on their own and open to multiple interpretations. So when that happens, it usually will benefit one group and disadvantage another. Rather than picking a side and risking a lawsuit from whoever was disadvantaged, we can ask the court to proactively settle the dispute, give the manager direction and peace of mind against a future litigation.
So when does probate not need to get involved?
There's actually two scenarios generally. The first is when a person passes away, probate would not need to get involved if there are no assets left in that person's name, or if everything transferred away automatically. A beneficiary designation is effective on death to transfer assets or benefits directly to named individuals or entities. A joint owner often enjoys a right of survivorship and continues as an owner if another co-owner dies. The takeaway should not be, however, that co-ownership and beneficiary designations are appropriate in all situations. There are many circumstances where adding an owner or naming a beneficiary can be as harmful or worse than letting something slip into a probate administration. The other side of that is when a person's alive. An individual who has powers of attorney to appoint health and financial decision makers generally does not need the probate court's help. There are, however, some circumstances when the court will still need to get involved despite having those powers of attorney in place.
So then why do people seek to bypass probate?
There's three primary reasons: the cost, the publicity, and the reduced control. Cost is just because anytime the court needs to get involved, there's fees. Publicity is because avoiding the probate process, a person privatizes their own affairs. And with reduced control, the court gets involved to make decisions over which we have little to no control.
Can you tell me a little bit more about increased costs?
Sure. Plainly stated, the court has to be paid for its time. In many matters, there are petitions and other documents that get filed. There's hearings that are heard, and all of those cost something. Judges, clerks, court registers, other support staff all need to be compensated for addressing an incapacitated individual's needs. And so the court assesses fees for many steps of the process. Many people want to avoid these fees and seek to avoid probate as a means of doing it. Probate costs can be avoided with proper planning, whether by preparing powers of attorney to appoint general durable powers of attorney, patient advocates to make health decisions, trusts, or other strategies too. But I'd like to clear something up. There's a lot of rumors going around that probate takes half or a third or some large chunk of someone's assets. It's simply not true. A living person under a conservatorship will have to pay for the court's involvement and the conservator for his or her time, but it's never a percentage of the person's estate. If a person has died and their assets are being administered through probate, many of the same costs are paid in addition to an inventory fee, which is based on the assets going through probate. It's still not that half or third that people are fearful of. It's a very statutorily defined fee schedule that lays out exactly what the fees are for a given value of assets. And as a couple of examples, an estate worth $250,000 would incur an inventory fee of about $550. An estate of $1 million would incur an inventory fee of $1,175. So it's much lower than what many people think. Alternative planning has its costs too, but it's oftentimes less than the cost of having no documents in place. Sometimes alternative planning can be fairly costly, but usually the benefits that it provides during a person's life or after they've passed can have significantly greater benefits than the cost of implementing the plan and administering it or having no plan at all.
Can you tell me a little more about the increased publicity?
Sure. Court's a public forum. If you want to know how public an administration is, ask any personal representative or executor if they've ever been contacted by a realtor to sell an estate's home. and that's regardless of whether there's actually any real estate to sell. It's because the information is widely available. Anyone who wants to observe a hearing is welcome to do so, and anyone who wants to participate in a hearing is also permitted. Files, statements, forms, they're mostly all available to the public if they're willing to pay a small fee. And many probate courts also track the status of the matters online, and so there's databases that have public search functions.
Can you tell us a little more about reduced control?
Certainly. A judge is most likely an absolute stranger to a protected individual, yet they're making very important decisions in that person's life. The decisions are based on the facts available to the judge, and in many situations, the preference of the individual would be vastly different from the way that a judge might decide a particular matter. The court doesn't know the family dynamics or the trustworthiness or untrustworthiness of certain individuals, so they're always going to proceed with caution. Judges err on the side of protection. By implementing someone's own documents, all the control can be retained by the individual. Additionally, the agents that one appoints for himself or herself can be provided much greater authority than what a court usually provides that same person. That's because the court isn't always willing to take the risks associated with our agents the same way that we would because of how well we know the people that we've selected.
So probate isn't needed if I need to make decisions for my spouse or children, right?
This is also a very commonly misunderstood aspect of probate court. Whether it's for incapacity or death of a family member, a spousal or parent-child relationship provides no automatic authority for someone to act. We should clarify that this applies to children over 18 years old. But what that means is that if your spouse or your child was involved in a serious accident, was unable to communicate, and you rush to the hospital to assist in making their medical decisions, there's no legal authority for you to participate in those decisions or even receive information related to the individual's condition. In most situations, the spousal or parent-child relationship would give that person priority to be selected as the individual's agent, but it still requires the court's intervention. Something to keep in mind is how time-critical many of these matters are. Using that last hospital hypothetical, imagine how urgent it would feel to be able to participate in a loved one's care, but needing to petition the court for the authority to make the decisions. With few exceptions, literally life or death, a person petitioning for authority to participate in the health or financial matters of another can expect to wait 4 to 8 weeks to have that matter heard by a judge in order to appoint a person who's legally authorized to act. Contrast that with just a few days, or sometimes even hours in some circumstances, to have paperwork drawn up with an estate planning attorney.
The probate process seems very elaborate. Do I really need to make my own documents?
No documents means that you've adopted the default provisions, which aren't always ideal. Intestate is a term that describes somebody who has passed away without a last will and testament. And in an intestate administration, we look to the statutes for guidance on all aspects of administering a person's estate, starting from who serves as that personal representative, all the way to who is entitled to the assets of a decedent. In most situations, a surviving spouse and children receive the assets of a deceased person, but the blood relation between the surviving children and the surviving spouse determines exactly how that estate is divided among them. All intestate estates typically follow a person's bloodline, but that too can have some negative implications. Consider a second marriage between two people, both of whom have children of their own. If one of them dies and a probate administration is needed, that surviving spouse is going to receive $150,000, or the first $150,000, plus half of the remaining assets. If anything is left, what remains would be divided among the deceased spouse's children. Even worse is at the death of that surviving spouse, because only that second to die spouse's children will receive everything, leaving the children of the first spouse to die with nothing. Taking matters into one's own hands can remedy these issues so that both spouses are protected during their lives and that their respective children can share the remaining estate assets when both of them have passed away.
So does a last will and testament avoid probate?
Another large misconception is that a will avoids probate. It's just the opposite. All wills, if used, require probate. The reason is that the document has no power on its own. It needs to be accepted by a court after being authenticated, and then it's used by the court as a guide to appoint a personal representative and distribute assets in a specific way. The appointment of a personal representative gives an individual the power to contact various financial institutions to administer a deceased person's estate. If someone simply walked into a bank of a deceased individual with that person's last will and testament, the bank would turn them away every time. It's an important distinction that while every will which is used requires probate, not all people who create wills will require a probate administration. If there's no assets left in a person's name, then there's no need for a probate administration, and the will just goes unused. Excuse me. I like to think of the preparation of a will as an insurance plan or a safety net. If it's needed, the guidance that it provides is very helpful, but if it can be avoided, it's usually for the best.
So is preparing a trust the only way to avoid probate then?
A trust is not the only way to avoid probate. A trust is one of the ways, but there are other strategies. Strategies already alluded to, such as beneficiary designations, joint ownership, or strategies not mentioned yet, such as Ladybird Deeds. Every person's situation must be carefully examined before a detailed plan can be formed. Depending on the situation, different plans are appropriate, but in most situations, a person's ideal estate plan involves a combination of these strategies for various reasons. Plans address issues such as taxes, creditors, marriages, divorces, potentially disabled beneficiaries, beneficiaries with money issues, beneficiaries with drug or alcohol issues, and other issues. There is no one-size-fits-all plan. Often, avoiding probate is one of many goals, and so more must be considered when deciding exactly how a plan is going to take shape. Take, for instance, an elderly couple where a wife is caring for her husband dealing with dementia. The husband would not be able to live independently if something happened to the wife. And in addition to avoiding probate, we also want to avoid a situation where the husband survives his wife and takes all of their assets to a nursing home where it would be rapidly depleted. Here, probate is one of many evils, and so a complex plan has to be formed to avoid the many evils that are out there.
So should probate always be avoided?
In general, it is ideal to avoid probate, but there are some circumstances where relief can only come from a probate court. Consider an 81-year-old husband and a 78-year-old wife with Alzheimer's disease. Let's assume they've got a home and $350,000 worth of assets. If I oversimplify this, the default rules would protect the home and around $130,000 of their assets for the husband. The other $220,000 would need to be spent before this wife would be able to qualify for Medicaid. Few people know that the federal statutes which govern the Medicaid programs specify that if a court has entered an order of support between two spouses, the amount ordered shall be deemed protected for the healthy spouse. This means the probate court possesses the ability to protect all of this couple's resources so that the husband can not only enjoy his quality of life, but so his wife can receive supplemental care from her husband, which he would otherwise be unable to provide. This is a strategy we have sought many times and a perfect example of when the probate court should not be avoided. Let me give you another example. Powers of attorney. They're great. They give power, the ability for another to stand in our shoes, pay our bills, make medical decisions. But on the flip side, there is no relinquishment of our own power. This means we're still free to act for ourselves, manage our own affairs, whether for the good or for the bad. We can also interfere with our power of attorney's ability to help us out. The law clearly states that even after a person has become incapacitated, they still possess the ability to terminate the power granted by a power of attorney. Also, doctors and hospitals must respect an individual's objection to unwanted health treatment. So when a person is willing to hand the reins to his or her appointed agent, all is well. But when a person refuses to allow the agent to act, probate must be involved. The court's determination of incapacity and the subsequent appointment of an agent, either a guardian, a conservator, or both, not only puts a person in the position of power over an incapacitated individual's affairs, but it also suspends the individual's authority over himself or herself. That shift in power, can only come from a court. Lastly, and as mentioned earlier, the court can proactively address anticipated conflicts. In situations where we know there's going to be a fight, reaching out to the court for instruction is sometimes the best way to go. In many situations, the fight can be avoided with proper planning, but sometimes we get involved after the planning window has closed. Consider a situation where an individual writes their own will and very clearly defines who the personal representative is supposed to be, but the will is extremely confusing regarding the disposition of their estate. In one provision, the majority of the estate is given to a longtime partner, and in another, everything is held for a relative. Rather than picking a side and being sued by the other, we will ask the court for guidance, and when a decision is made, we can administer the estate without fear of a lawsuit by the disadvantaged side.
So it looks like we have some time now for some questions. And Joe, I am sending you some of the questions that I've gathered.
Okay.
And let's go ahead and address these. I will put in a caveat here that Scott is licensed in the state of Michigan, correct?
That's correct, yeah.
And so these answers are not to be taken as like for every single state. And so be just aware that it may be different in your jurisdiction. Okay.
Okay, so here are some of the questions that we have, Scott. You said in some situations, naming an additional beneficiary can be problematic. Can you expand on that?
The beneficiary designation takes effect the moment that an individual passes away. You still need to verify with a financial institution exactly, that the person has passed away and the individual has to claim the assets. But there's nothing to serve as a barrier between the individual named and those assets. So if an individual has anything going on, say that they're in the middle of a lawsuit, a future judgment against that individual might cause all the assets that are received to be lost. If that same beneficiary has disability and they're receiving any sort of public assistance, the public assistance that they're receiving would likely be cut off after there's a receipt of the assets. And it's not something that the beneficiary can simply pass on in order to avoid the interruption of those benefits. Once the individual is entitled to receive them, the damage has been done and they have to be dealt with in a different way than how we would typically deal with them proactively if we know that we want to name a beneficiary or designate a certain beneficiary of assets, but they might have some of these issues going on. So while they're good on the hand that they are a direct transfer, they're bad in the sense that if anything is lurking, in the periphery of that beneficiary's life at the time this transfer takes place, it could be very, very harmful to a beneficiary.
Okay. What is your opinion of putting one's children or one of the children's name on a house to avoid probate for the house?
That's probably one of the worst things that you could do with respect to a piece of real estate. And there's several reasons, probably too many to actually go through right now. There's tax issues, there's capital gains issues, there's potential creditor issues. But maybe one of the worst things is imagine adding a child onto a home and then deciding at some point in the future that you don't want to live in the home anymore, you want to sell it. What happens if your child doesn't want to sell it? What happens if they have had a falling out with you? And typically people would say, well, I would only do this if I've got a good relationship with my children. But I've actually seen situations occur where somebody's added a child onto a piece of property because they wanted them to have it at the time. And later they either changed their mind or something happened where there was a little bit of a fallout and they decided that they wanted to sell it or remove the child from the property. The only way that they can actually do that is if the child agrees to go along with whatever that wanted action would be. And so there's been a handful of times where there isn't anything that we can do. If there's a creditor issue, if that child is being sued, an individual could potentially have a claim levied against their own home because the asset is an asset of the child. And so any assets that they may have could be collectible in a judgment against them. There's also potential issues from an elder law perspective. Adding somebody onto a piece of property during your lifetime is essentially a gift, a fractional gift of equity. And so if you've given them assets, it could potentially come back to cause some severe penalties if you ever need a higher level of care, and you might look to a public program to provide support. What we normally would recommend as an alternative is something called a Ladybird Deed. The formal name is an enhanced life estate deed, where the individual keeps the property. They retain all ownership and all control during their lifetime, but at their death, they can name a designee similar to a beneficiary, where the property will transfer automatically. So it will avoid probate, and you also avoid a lot of those other pitfalls that are lurking out there if you just simply add somebody onto a piece of property.
I'm gonna try to paraphrase one of these questions for you.
And before you do that, I do want to say Ladybird Deeds are not available in all states.
Correct.
So that will determine whether or not that strategy is possible.
Yes, and they're also very, very specifically drawn up. There's a lot of technical language that needs to be referenced in them. Michigan honors them. I know a handful of other states do, but anybody who's interested in it, I would certainly have them reach out to an attorney to make sure that it's something that's available in that jurisdiction. I'd also suggest that they have an attorney prepare the deed itself, rather than either trying to do it on their own or trying to go through some sort of real estate professional, because there's a lot of legalese that needs to be contained on those deeds. And if it's done wrong, you can end up in probate, or it can actually cause title issues, which would be even worse. So it's not something to try and handle on your own.
Okay, so I'm going to try to paraphrase this question a little bit. The parents had 2 children,
Okay.
and one of the parents passed away, and the other parent is still alive but has dementia. One of the kids has power of attorney, and his son, it looks like maybe a trustee. Is that too much concentrated authority for that, like, family member type of thing? I'm trying to paraphrase it. So
If I'm understanding the hypothetical, it may be, it may not be. It sounds like it may be too late, because if the surviving parent, who is the one who created these documents or who reserved the power to make modifications to the documents, is no longer competent, they may not be able to change them. And so the individual, the one child with all of that power, that may be just what essentially the family has to accept for now, unless that individual is mismanaging, in which case, that can be addressed with them to either step aside or to provide information to clarify what actions are being taken. Or in some circumstances, that is also a case where you need to seek the probate court's intervention so that they can look at it objectively, determine whether or not there's any wrongdoing, and either remove somebody or put restrictions and protections in place so that everybody feels like the management is appropriate.
okay, and then so I'm gonna try to read this question off also. It's for people that die intestate. So they're saying, if a parent is remarried and dies, if he dies without a will, the new spouse does not have to give or will anything to his natural children, even though they did not have children together. Is that correct? Do his natural children have a claim to anything?
Children do have some statutory claim. It's relatively small. Again, depending on the makeup of that family relationship, the spouse is going to be entitled to the lion's share. There will be a percentage that goes to the children of the individual, but typically they're, for the most part, they're not going to be included because the general statutes are going to provide for the surviving spouse. And then the real harm comes in when any assets that transfer to that surviving spouse, when that surviving spouse passes, all of those assets are going to follow the bloodline of that surviving spouse. So the children of their deceased spouse, or any of that bloodline, is going to be completely excluded.
Okay. And what about single people with no children? Do they need estate planning?
Certainly. Everybody, it doesn't matter what your situation is, anybody can get sick. So the powers of attorney are important for everybody. Once you turn 18, I was talking about if somebody was injured and a family member went to the hospital, we've seen that happen in situations where a child is in college and for whatever reason, they're injured. Parent goes to see them in the hospital and they're turned away in the waiting room and they can't believe it. Situations like that, the children need to have powers of attorney that appoint their parents as an agent so that their parents can manage financial matters, deal with healthcare issues, that kind of thing. For single people without kids, they're probably the most difficult to plan for because they don't have this easy answer of who to designate as a beneficiary. But I still think it's important for them to have some idea of where they'd like things to go because it will find another family member. And even if they're okay with what the defaults are, having a document in place can facilitate that process a lot easier. Also, if there isn't any family, and we've had situations where somebody has no spouse, no children, they're pretty much the only surviving member of their family. If they want assets to go to a charity, I think it's a great opportunity for them to put the documents and the designations in place for them to be able to identify a charity that pursues a cause that they're in line with so that they can make sure that their money is being used for a purpose that they believe in. So yes, I think everybody should have some form of estate planning. The primary documents, the most important documents are going to be powers of attorney. Everybody needs those.
Again, thank you so much, Scott and Joe, for your wonderful presentation, for explaining some of the ins and outs of this. It's funny because you don't think you'd have to think about planning for retirement, but this is specifically planning for passing. So everyone will have to go through that, even though we won't see that what results afterwards. So thank you very much. To our attendees, I want to thank you for attending. Look for an email soon with a replay of this event, and you're welcome to share that replay with your friends and family. Here at Advice Chaser, we're all about helping you find a financial advisor who's a great fit for your life and your financial questions. Our matching service is free to you, and every one of our advisor partners has committed to offer a free initial consultation to anyone we introduce them to. So you just have to find out more by going to advicechaser.com and clicking on the link to find an advisor. Once again, from Advice Chaser, thank you everyone for attending. Thanks to our speakers, and we'll see you at another webinar soon. Bye, everyone.
Thank you.